And last but not least, we have Plantation at PONTE VEDRA versus Wells Fargo.
Good morning, and may it please the court. I'm Austin Hamilton on behalf of the appellant, the Plantation at PONTE VEDRA. I would like to reserve 5 minutes. We're before the court on an appeal from a final judgment that was entered after an order granting Wells Fargo, the appellee's partial summary judgment, and we're also on appeal of an order denying entitlement to attorney's fees. We believe the trial court erred in granting summary judgment for Wells Fargo. I plan to address 3 specific errors in my argument today. The first one is that the trial court erred by applying section 720.3085 sub 2, that's commonly referred to as a safe harbor provision, retroactively to divest the association of a vested contract right under the declaration.
Now, the first mortgage was recorded first, right?
That's correct, Your Honor.
And then the lien was recorded subsequent to that, correct?
That is correct, Your Honor. The second error I plan on addressing is the trial court's finding that Article 6, Section 7D of the declaration, the 6th amended declaration, was illusory. And the third argument I plan on addressing is the trial court effectively rewrote the Plantation's 6th amended declaration with regard to the requirement of initiation fee. What the trial court did is the trial court found that anyone who takes title to property that's located within the Plantation's confines, if they take title by any means other than a deed, that they're not responsible for paying an initiation fee. The declaration does not say that.
Now, how do you respond to the argument that the relevant date to determine the statute's applicability is not the date that the mortgage was issued, but when the action occurred, when Wells Fargo took title to the property?
I don't believe that it is the date of the title when Wells Fargo took title to the property. I think based upon EcoVenture and on this court's decision this court's decision in EcoVenture and on Coral Lakes, the applicable date for vesting purposes of determining whether the declaration applies or whether the statute applies would be the date that the mortgage was issued. In this case, the mortgage was issued in May of 2007. At that time, the 6th amended declaration was in effect. The 6th amended declaration went into effect in 2005, and Wells Fargo agrees that the 6th amended declaration is the applicable declaration that applies. So I believe that the vesting with regard to what you look at, whether you look at the declaration or whether you look at the statute, that in this case, because the mortgage was issued prior to the subsequent statutory change which took place on July 1st of 2008, that you look at the declaration. And under the declaration, it provides for joint and several liability.
Was the association made a party to the foreclosure action?
That's correct. The association was a defendant in the foreclosure action.
And when the court foreclosed the bank's interest and held that it was superior, how did that impact, in your mind, the past due dues? Let's separate out the initiation fee for just a minute, but let's talk about the dues that had accrued. I guess 2 things. Number 1, at the time they recorded the mortgage, there was no recorded lien at that point. Is that correct?
I don't believe that there's anything on the record that says that, but I believe that Your Honor is correct.
So when they joined the association in the foreclosure, and I'm assuming that they make the general allegations that our interests are being the bank's interests are superior to everybody else's, the court ultimately grants a foreclosure. Why doesn't that wipe out whatever interest, if any, the association had?
Well, Your Honor, I think that issue has been addressed in numerous courts. One of the main cases was Aventura. Aventura was a 3rd DCA case, and in Aventura, the court acknowledged that a homeowners association lien survives the foreclosure. The homeowners association lien itself is not automatically extinguished by the foreclosure. If it was, we wouldn't have had the decisions in Coral Lakes. We also wouldn't have the decision in EcoVenture. And under the Plantation's declaration, it says that Wells Fargo is personally liable for the charges that were incurred by the prior owner. So I don't think that the foreclosure, the way that I understand your questions, I don't believe that the foreclosure judgment in and of itself wipes out all the liens. Really wipes out all the debt that is owed, since it is a personal obligation under.
So even though their mortgage was recorded before any lien, And even though the foreclosure judgment held that their interest was superior to any of the subordinate lien holders, your position is that that doesn't wipe out whatever monies that they owed because of the language in there that says they're jointly and severally liable.
Absolutely, Your Honor.
Are you saying that the lien is discharged or wiped out, but the debt isn't? Is that the distinction you're trying
I think that is the distinction, Your Honor. I think the best way to look at it is you look at that, it's Article 6, Section 7D of the Plantations Declaration. That article includes a subordination of lien to mortgage. It has a subordination provision. Underneath it, it has an extinguishment provision. If you look to the declarations that were at issue in Coral Lakes, EcoVenture, and also in US v. Bridgewater, each one of those cases, they have a subordination and an extinguishment. Here, the Plantations Declaration, it has a subordination provision, but it doesn't have the extinguishment. It says it may extinguish. It does not say it shall be extinguished.
Oh, but
that's a big distinction.
If it's subordinate, I mean, doesn't that, I mean, the practical effect of that, if it's a subordinate interest, isn't it wiped out by a superior foreclosure? I mean,
well, I don't think it is, and I think that goes back to Chief Cohen's comment of whether the debt itself still remains. Whether the lien or the lien with regard to the real property, a claim of lien with regard to the real property, whether that exists is not the question. It's whether the underlying debt, which is under the Plantations Declaration, it's a continuing lien, whether that underlying debt still remains.
I mean, I understand that as your argument, but it just seems that interpretation really makes the subordination of liens meaningless if the obligation is still enforceable.
Well, I don't think it does, Your Honor, because what it does is it clears title to the actual property. If you, I'm sorry, go ahead.
I want to ask you
Sure.
this, and let's take the unusual example where there's money left. So the bank forecloses, the association participates, and lo and behold, it sells for more than the mortgage. So let's say it sells for $500,000, the mortgage was $300,000, and you're saying that the association will get its money first out of the remaining money. Well, let's say it sells for $350,000, and the mortgage was $300,000. You're saying that because there's a personal obligation that the association will get the $50,000 first, which is kind of turns the term superior and inferior upside down.
Your Honor, my position is not that the association would get it first. My position is that if they're in your scenario, if there was some amount of homeowner association assessments that were outstanding, that debt would still remain due by the next property owner. So it's not that the plantation or any homeowners association under these facts would be first in line for payment over the bank. It's the fact that those amounts still exist, and I think that is supported.
Wouldn't that really prevent, no bank in their right mind would ever loan money thinking that if they couldn't wipe out the inferior interest, including the debt, not just the lien, but the debt, no bank's ever going to loan money in that subdivision. I mean, if that's the way we do things, I mean, the whole idea of banks is they want a first loan, a first lien rather, and know that if they wipe out, they're good to go. Now, whether they're good, I know we've got some issues as the application of the new statute, but.
Well, I would suggest two things. First, not all banks are going to require them to be the first mortgage. A lot of banks will actually issue the second mortgage. But here, and it was in one of the cases that I cited in my brief, and I'm losing it right now.
Do you think they're going to issue a mortgage subordinate, that's secondary to homeowners association dues?
I'm not going to put myself in the position of what the bank's going to do. I'm telling the court that based upon the facts here, the bank does not have to issue a mortgage if it disagrees with this declaration. Banks don't have to come in. Banks on notice, as anyone else is on notice of a recorded homeowners association lien because it's in the property record. The bank sees that. They have a copy of it before, when they do their underwriting, when they decide whether they're going to issue a mortgage on that piece of property. They don't have to do it. I think Flagler Federal is a case that specifically says the bank are going to take title. The bank the bank, when it issues a mortgage, is on notice of the declaration, and if the bank doesn't like the language of the declaration, the bank does not have to extend that mortgage. And this doesn't apply to every single homeowners association out there. This analysis really depends on the underlying facts of the declaration in each homeowners association. That's why I drew the distinguishment between EcoVenture and Coral Lakes. You really have to look at the language of their declaration. And I believe it was the Ballantrae case, which is a recent case out of the second DCA, that said that there is a distinguishment between whether a lien is subordinate and whether it's extinguished. And the court in that case never reached the final decision. But in that case, the court drew a distinction between the declaration that was at issue in the Ballantrae case and the declarations that were at issue in EcoVenture and Coral Lakes. And EcoVenture and Coral Lakes, they have both the subordination and the extinguishment provision. And here, we don't have that extinguishment provision.
Do you have in front of you Article 6, Section 7D?
Sure, Your Honor.
If you stop at the end of the first sentence, would you agree that says the bank's first mortgage is superior to any lien that may accrue subsequently in behalf of the homeowners association?
I would agree that it says that the bank's mortgage is superior to any claim of lien that was filed by the association, yes. And I'm not trying to split hairs with that argument.
Okay. But you're saying the second sentence with regard to a judgment or the debt as opposed to lien says that, you know, it's in the discretion of the homeowners association on whether to release the personal debt, if you would. Is that what your argument is?
For the most part, I would agree with that. And I don't think it should be, if the association doesn't want, or if the association wants to release the debt, then they can do it. I think that an association and its board is governed by the declaration, which is its constitution. If the declaration didn't include the plantation or the association's ability to allow that underlying lien to be extinguished, then the association would absolutely have to enforce it against every single subsequent person.
Then why even have the first sentence if that's your interpretation of the effect of the second sentence?
Well, I have the first sentence in subordination.
Yeah, I mean, if it's not going to be superior, why even have that sentence suggesting to the bank that their first mortgage would be superior? Well, I mean, your argument is, you know, if the bank doesn't like the documents, you know, then they don't have to loan the money. But to me, that first sentence tells the bank, your interest is superior, period. And then you're suggesting that the second sentence says, almost like a just kidding.
Well, I'm sorry if I'm not explaining myself correctly. I don't think that it is your interest is not superior. I think for purposes of foreclosure, that the mortgage holder would be able to have priority with regard to foreclosure. But we were talking about the underlying debt being a personal obligation, regardless of whether that debt holds to that property or the next property owner. Under Article 4 or under Article 6, Section 1, it says that each owner, regardless of how they take title to a parcel of property, is jointly and severally liable for the debt that's due on that property.
It's hard to find that someone, you know, at least from my perspective, that someone has a superior lien if they can end up having to pay money to the inferior lien. Like I said, it kind of turns the word superior and inferior upside down.
Well, Your Honor, I think it depends on who takes title at the end of the day. The declaration is written in a way.
Theoretically, if the association was owed the $100,000, they got a judgment, they could then execute on the bank's interest in that condo, which would indicate that their claim was superior, not inferior.
Well, I'm not so sure that I agree with that. I don't.
What's wrong with that? I mean, if you all got a $100,000 judgment, $150,000, $180,000, whatever it is, against the bank, couldn't you, you know, seize this unit through attachment, execution, whatever proceedings?
I guess in theory, Your Honor, but I don't think it would ever get that far. We're not seeking to enforce a claim of lien here with regard to foreclosure of a parcel of property. What it is it's simply a money judgment that we would go after the banks. Whether we go after the bank and after we get a judgment, we execute on it.
I think Judge Vander's point is if you get a judgment for the unpaid dues, you could then turn around. The bank's now taken title. Let's assume they haven't sold it. They've taken title to this lot. You could just turn around and execute on the lot, which kind of turns the whole idea of their superior interest on its head.
Or we could execute on a bank account that the bank owns. I mean,
grab the money that's in the till at the local, branch. But I'm kind of focusing on this particular property.
Okay. Well, I would say, that's not part of the record, I guess, is all I'm getting at. The
Well, we're
plantation has
talking
never done that, and I'm not
conceptually.
trying.
We're talking the framework of your argument allows for that to occur, does it not?
I'm just not so sure that it does. I mean, it allows us to go after and get a personal money judgment against the bank, whether we execute on on an account by the bank or what other property that the bank owns. It's not that the way that the declaration is written is not that the plantation, as the homeowners association, can then go after that parcel of property.
You are into your rebuttal time.
I would like to reserve the rest of my time. Thank you.
Could you pull the microphone down just a little?
May it please the court, I'm Hope Keating, representing the appellee Wells Fargo. The trial court correctly held that the application of Section 7203085-2C does not violate Plantation's contractual rights under the Sixth Amended Declaration because, as found by the trial court, there's a subordination of lien provision in the declaration that makes a clear promise to mortgagees, inducing them to extend money to people to buy property in the Plantation neighborhood by promising that the mortgage will have lien priority over homeowner assessment association assessment liens. The declaration also promises that provisions pertaining to mortgagees are to be construed as covenants for the protection of the mortgagees on which they rely in making the loans. And these provisions provide a level of safety for the mortgagee in lending money or assuming mortgages. Pursuant to Florida law, if there's a subordination of lien provision in a declaration so that the mortgage lien has priority over assessment liens and the homeowners association is joined as a party to the proceedings, the mortgagee is not liable for assessment liens accrued by the delinquent homeowner. To construe the second clause of the subordination of lien provision, as urged by Plantation, to mean that Plantation has the option of extinguishing its homeowners' assessment liens for pre-title amounts as to a first mortgagee that accepts title pursuant to foreclosure after the foreclosure process is over, would not only be irrational because the second clause effectively nullifies the first clause and undoes what the first clause promised, and it also makes Plantation's obligations illusory because it imposes no obligation at all on Plantation with regard to subordination of the lien after the mortgagee has lent the money or assumed the loan. It says, lender, you lend money to somebody to buy a house in our neighborhood, and we will subordinate your lien so that ours will be extinguished during the foreclosure process to you, and then say, oh, we will do that only if we want to. It has to be assumed that the parties intended a rational result with this contract. Wells Fargo obviously relied upon the subordination of lien clause, and the only reasonable way to reconcile those two clauses is to assume that the drafter intended the second clause to apply to a third-party purchaser that assumed the contract pursuant to the foreclosure, not a mortgagee that falls within the subordination of lien clause, and that as a matter of reality might very well have to take the certificate of title to the property as part of the foreclosure process.
Let me ask you this, going back to the first sentence in Article 6, Section 7D, it also refers to initiation fee, not just assessments, but initiation fee. What initiation fee are you arguing they're referring to? The initiation fee by the borrower or subsequent initiation fee to be imposed against the lender, or what? The sentence says the lien of the charges provided for herein shall be inferior and subordinate to the lien of a mortgage held by a mortgagee now or hereafter placed upon any parcel, subject to assessments or an initiation fee, so long as such mortgage lien is recorded prior to any claim of lien filed by the association.
Well, I think that could certainly be construed as also pertaining to the initiation fee, but what the trial court found was that the initiation fee was a separate provision, and and also, I think it was conceded below that the initiation fee did not fall within the parameters of 720, the safe harbor provision. With regards to the joint and several liability provision, that provision, to construe that as applicable to the mortgagee would violate the letter and the spirit of the contract. The most specific provision in the contract pertaining to pre-title assessments with respect to mortgages and mortgagees is the subordination of the lien provision. And when the mortgagee lent money, it had a right to rely on that subordination of lien provision. The two provisions are not compatible. And to the extent there's an ambiguity in a contract, it should be construed against the drafter of the declaration. The only way, really, that Section 1 and Section 7D can be read together is if the second sentence of that subordination of lien provision pertains to a third party that takes title pursuant to a mortgage, pursuant to a foreclosure. And I'd also point out that case law indicates that any issue regarding a mortgagee's responsibility for pre-title assessments due pursuant to a declaration needs to be addressed in the foreclosure proceedings to which the homeowners association is a party. In the Bridgewater case, that case involved a declaration that provided for personal obligation for association assessments for owners and subsequent owners. It also had a subordination of lien provision. And the property went into foreclosure, and the homeowners association was joined as a party to the proceedings, but didn't raise any issues as to its rights under the declaration, and the property was sold clear of all claims except for those under Chapter 720. The bank took title, and then the homeowners association came back later and demanded pre-title assessments, stating that the subordination of lien clause was invalid and inapplicable, and that they were owed pre-title assessments pursuant to the personal obligation clause. The Middle District of Florida, applying Florida law, stated, any potential superior lien Bridgewater had based on its contractual right from the declaration was extinguished in the foreclosure proceedings. And I think if you look at the Coral Lakes case, all of those issues pertaining to pre-title assessments as to the mortgagee's responsibility were decided at the foreclosure stage. And the Ballantyre case, basically that case says there are two ways that pre-title assessments can be eliminated as to a first mortgagee once it has acquired title. There can be specific language in the declaration, or the mortgagee can join the homeowners association in the foreclosure action. And although the language in the Coral Lakes case and the Echo Venture case, those subordination of lien clauses did contain additional language, I would suggest that what the court really looked at was a subordination of lien language. The Coral Lakes case, the holding was very clear. It said, we conclude that because the declaration's plain and unambiguous language subordinating any claim for unpaid homeowners association assessments to a first mortgagee's claim upon foreclosure or deed in lieu of foreclosure controls and absolves the bank as first mortgagee from liability for any assessments accruing before it acquires the parcel. And in the Echo Venture case, that subordination provision was a very ordinary one, almost like this one. It did include another sentence that said what would happen to those unpaid assessments after the foreclosure. They would be paid by the owners, but those cases really focused on the subordination of lien provision that the mortgagee had every right to rely on before before money was lent or the mortgage was assumed.
Let me ask you to shift gears for just a minute to the initiation fee. You would agree with me that that's not a pre-title assessment. If it's applicable at all, it's post-title, correct?
That is what the trial court found, correct.
I mean, do you differ from that? I mean, it's only due upon the transfer. So the transfer doesn't occur until there's a closing or a deed of title, a certificate of title from the clerk. So those obligations can't come up before the foreclosure. They only come up afterward.
That's correct. That's correct.
Let's talk about, I mean, it seems to me that your entire argument was focused on the word closing as opposed to the words transfer of ownership of the parcel. It says that the new parcel owner, and do you agree that you're a new parcel owner? I mean, I looked at the definition of parcel, I looked at the definition of owner, it looks to me like you're a new parcel owner.
Right.
If you're a new parcel owner, at the time of closing the transfer of ownership of the parcel, I mean, if we only looked at that word closing, it seems like your whole argument that, you know, the only way that you can have a closing is, you know, you get the title company, or you get the two lawyers together, and I hand you the deed, you hand me the check, and that's a closing. I mean, isn't that a little bit of a narrow definition? I mean, isn't the whole idea of a closing is when the transfer of title takes place?
Well, I want to just respond first about the definition of owner. When the declaration is, the declaration that was in place at the time that the mortgage was issued, the definition of owner was defined expressly to exclude those having an interest merely as security for the performance of an obligation. So
clearly, the bank, until it foreclosed, wasn't an owner. No
that's
question
correct.
about that.
That's
But
correct.
once it forecloses and takes title, why isn't it an owner?
Well, first of all, if Plantation had wanted the initiation fee to be applicable to those acquiring title by certificate of title, it could have used the term deed or other transfer document like it did in two other places in Article 6, specifically in Section 1. It used that term deed or other transfer
Well, but if we
document.
focus on this language and we say the initiation fee shall be due to the association by each new parcel owner at the time of closing the transfer of ownership of the parcel. So doesn't our inquiry come down to, is this a closing on the transfer of ownership to the parcel? Isn't that really what we need to examine?
Well, I think what the court should examine, as the trial court examined, was giving the common usage to those words and those plain.
This is a matter of contract interpretation, so we're not obligated to defer to the trial court's
Right.
view on that, are we?
No, you're not, Your Honor.
But your view is a very narrow one, that the word closing means you and I sit across the table from each other with our clients, I hand you the deed, you hand me the money, that's a closing, nothing else is a closing.
Well,
So
a
if
closing,
I were to
a-
gift you the property, you know, you're my best friend, and I just say, I want you to have it, and I transfer the deed to you as a gift. There's no money that takes place, there's no title examination. Your view is that you're not a new parcel owner that would owe a initiation fee because there wasn't a formal closing?
well, under these specific facts of our case, the
Go
title,
back to my hypothetical.
Okay.
So I think we both agree that if you have the typical closing, two lawyers across the table with their clients, check and deed, that's a closing, right?
yes,
And so the new owner owes the initiation fee.
yes.
All right. I now gift you, I'm the owner, I gift you the property because I like you so much. So now you're the new owner. Do you owe an initiation fee?
I would say that, first of all, that type of a transaction could be deemed a closing, because a closing is the final transaction between a buyer and a seller, whereby documents are finalized and the property is transferred by a deed.
Is it the final transaction between a buyer and a seller, or is it the final transaction between someone who has the authority to convey title and the party who receives title? I mean, here, the court gave the clerk of the court the authority to convey title, and they did. So how is that transfer of title any less of a closing than me gifting you the property or us sitting across the table transferring money for a deed?
Well, I think the fact that the provision uses both terms, deed and closing, it uses both of those terms. And to the extent there's any ambiguity in that provision, it should be construed against the drafter of the declaration.
Final closing transfer of ownership of the parcel. I don't see the word deed there.
It's also in that provision, perhaps not in that sentence, but it is in that provision. And another important point, Your Honor, is that under the facts of this case, a declaration should be construed to reach a conclusion that comports with logic and reason. And here, Wells Fargo has acquired the property pursuant to a foreclosure, whereby it, out of necessity, to protect its interest and to mitigate its damages, and it's acting as a pass-through and will be disposing of the property as soon as possible. And to construe the contract to require it to pay $40,000 now to Plantation, and then when it is able to sell the property by deed to someone in 3 or 4 months, or however long it takes, and for that owner to also have to pay Plantation $40,000, that would result in a windfall for the association, and I submit an illogical result.
Let me ask you, on a will, say the owner dies, and there's a will, and it goes to a new person, and the personal representative, I guess, is authorized to give a deed to that new person, or how does it, would the beneficiary in the will have to pay the initiation fee?
I believe that might be a situation that's excluded specifically in the provision. I believe so. I believe that is excluded. I believe so. I think here the drafters of the declaration have made an exclusion by using those terms, deed and closing.
Where's the word deed, if you can point, because I need to go back and look at the record.
It says the initiation fee amount for new parcel owner shall be that amount in effect on the date the ownership is transferred as indicated on the deed to the parcel.
It's about 1, 2, 3, 4, 5, 6, 7 lines down. But those are the words that the drafter of the declaration used, and if they had wanted it to apply to a certificate of someone acquiring title by certificate of title, they could have used the language that they used in the other part of the article. If there are no other questions on that issue, I'd like to talk just for a second about the attorney's fees cross-appeal. In Florida, the party that prevails on the significant issues is the party that should be considered the prevailing party for attorney's fees. And here, Wells Fargo prevailed on the significant issues in the litigation. And those were whether or not 720, 3085, whether or not that safe harbor applies, and also on the initiation fee issue.
Let me ask you, as far as the post-assessment dues, I know in answers to interrogatories, you all said you weren't disputing it, but did you ever pay the monies as, as each month came up?
I believe those were stipulated to in the final judgment, but not during that time, no.
How would that be different than another homeowner who keeps saying, yeah, I know I owe the money, but never pays it?
Well, I mean, the money now has been stipulated to, and the interest owed on those fees. And I think one of the arguments that opposing counsel made was that a tender somehow takes that issue out of the litigation. But, that just stops the interest when somebody makes a temporary.
Well, as far as the post-assessment dues, if you all didn't ever tender the money as each month came up, did they prevail on that?
Well, I think
you all defeat them being the prevailing party on that by saying, well, we know we owe the money.
Well, it was never a significant issue during the litigation. That wasn't an issue that was litigated or that significant time was spent on. I think the trial court, pointed that out, that if it wasn't conceded in the counterclaim, which it may have been, it certainly was conceded 2 weeks later in the interrogatory, and that was it. It wasn't an issue in litigation anymore after that. The other issues were the ones that were litigated. Thank you.
Thank you.
First off, I want to point the court's attention to the case of it's LR5A versus Little House and also Iberia Bank versus Dower Holdings. I cited both of those cases. In those cases, the court held that Section 720.385's application cannot be determined in the foreclosure action. So it can't, that issue, which Wells Fargo's counsel said should have been determined in the foreclosure action, actually can't be determined in the foreclosure action because it's not until after property is taken that issue can even be determined. In the foreclosure action, we don't know who's going to take title to the property, and therefore it can't be determined at that point. With regard to the initiation fee, Judge Orfinger, you asked whether the initiation fee is a post-title charge. The answer to that question is yes, it is. The initiation fee obligation to pay the initiation fee does not come due until the title is actually transferred. It has nothing to do with pre-title assessments. Those are two separate issues.
When the bank gets the title in the foreclosure action, it's due and owing, and then when they sell it in 2 months, another initiation fee is due and owing?
That is correct, Your Honor, under the interpretation of the declaration. Whether the bank actually does sell in 2 months, I mean, that's an open question. A lot of the cases, or a lot of the ones that are owned by the bank actually don't get sold that quickly. It takes a while, but
saying hypothetically.
Hypothetically, yes, Your Honor. And also hypothetically, anyone who takes title at the foreclosure sale, whether it's the bank, whether it's a third-party purchaser, whether it's someone who obtained the bid from the bank in order to take the title at the foreclosure sale, or anyone who buys it from their neighbor, from their friend, is required to pay an initiation fee.
Well, let me ask you this.
Yes.
The initiation fee can change. I mean, right now it's $40,000. It could have been 33 years ago. It might be 45 next year, whatever. So to determine what the proper amount is, your declaration says the initiation fee amount shall be the amount in effect on the date the ownership is transferred as indicated on the deed to the parcel. What does deed mean in that sentence?
Well, Your Honor, as I've explained it in my brief, my understanding is in order to interpret the initiation fee provision, the court has to construe the entire document. So it's not just looking at Article 6, Section 6, it's also looking at the definition of initiation fee and an owner. When you read it all together, an initiation fee is due from anyone who takes title to the property, whether it's by deed or by certificate of title. I believe the reference to deed in that provision is referencing the document that actually transferred title. It's my position that a deed is a legal equivalent, or I'm sorry, a certificate of title is a legal equivalent of a deed. The idea is that both of those two documents are the document that actually transferred title. Here it does use the word deed, but when you construe Article 6, Section 6, with Article 1, with regard to the definition of initiation fee, when you construe those two together, as the court's required to do, I believe the initiation fee is due from everyone, regardless of whether they take title to a deed.
So any form of a title transfer, in your view, would require an initiation fee.
That is correct, Your Honor.
So, is there a provision in there that excludes transfers through wills?
There is I'm glad you brought that up because that is an issue I wanted to address. There is a provision in Article 6, Section 6, and it says when, it gives 3 exceptions for when an initiation fee is not due. One is a preferred builder who takes title from a developer. The second is an intra-family title transfer. And the third is when a member dies and the property goes to the member's spouse or surviving children.
So if I gift you my property, just because I like you so much, that would be an event that would trigger an initiation fee? If you're not a family member?
Yes.
You know, you're just my best friend and I want you to have it.
Yes, if you gift the property to someone else, if you sell the property to someone else, yes.
Okay, I'm not talking about selling, I'm just talking
Okay,
about
yes.
gifting. I gift you the property, that triggers an initiation fee.
Yes, Your Honor.
I just wanted to understand, you know, where we are.
Sure. The idea of initiation fee is due from each subsequent property owner. So everyone who takes title to property within the association is required to pay the initiation fee. The author of the declaration included those 3 people that I just mentioned who are not required to pay initiation fee. The author did not include foreclosing lender. It did not include someone who takes title to a title via foreclosure. It did not include anyone who takes title other than by a deed. If they wanted it to be that way, they would have put it in there. The inclusion of one thing means the exclusion of the other.
All right, thank you, counsel. You've exhausted your time.
Thank you very much.
All right, we will be in recess.
Thank you all.